I'm Ros Davey. I'm a partner in the Employment Law Department at Bowman Gilfillan. Employers are often faced with employees who are absent from work without leave. There are, broadly speaking, three categories of absence without leave: absenteeism, abscondment, and desertion. Absenteeism occurs where an employee is absent from work for short periods of time, or where the employee arrives late for work or leaves early, or where the employee is not at his workstation during the workday. Absenteeism does not usually lead to the impression that the employee does not intend returning to work. Depending on the severity and or the duration of an absence, absenteeism may be deserving of a range of disciplinary sanctions, from verbal reprimands to dismissal. Obviously, dismissal will only be justified in instances where there has been a lengthy absence from work, alternatively in instances of repeated absenteeism, where the employer has followed progressive discipline and notwithstanding this, the employee fails to rectify his conduct. Obviously, whether or not dismissal is appropriate for absenteeism will depend on the circumstances and the length of the absenteeism and the employee's reasons for his conduct. For example, an employer may find it difficult to justify dismissing an employee where the reason for an employee's continued late coming is as a result of the employee experiencing difficulties with public transport, where the employee is dependent on public transport. Abscondment, on the other hand, usually occurs where an employee is absent from work for a sufficiently lengthy duration without notifying the employer of his whereabouts and the anticipated duration of this absence. And this leads the employer to conclude that the employee does not intend to return to work. In order to easily distinguish between absenteeism on the one hand and abscondment on the other hand, it is advisable for employers to put a policy in place specifying what duration or what length an absence will be justified before it is considered to be abscondment. Abscondment may well justify dismissal as an appropriate sanction, but this will depend on the duration of the abscondment, the reason for the employee's absence, and the reason for the employee's failure to notify the employer of his whereabouts. Another thing that the employer will need to take into consideration is the employee's disciplinary record. Employers must be careful before dismissing an employee for abscondment that they follow a procedurally fair process, and in this regard, the employer will need to advise the employee of the charges against him and of the date for the disciplinary hearing, and then convene a disciplinary hearing before making a decision on whether or not to dismiss the employee. In the event that the employer is unable to contact the employee subsequently returns to work, the employer should then give the employee an opportunity to explain why he hasn't been at work and why he hasn't contacted the employer. And only after that should the employer make a final decision regarding the employee's dismissal. Desertion occurs where an employee absences himself from the workplace and either expressly or impliedly indicates to the employer that he doesn't intend to return to work. Even in this situation, although an employer it might be academic, with the employee indicating that he doesn't want to return to work, it may still be advisable that the employer convene a disciplinary hearing, charge the employee, and dismiss the employee. That's to give the employer some sense of certainty. What could happen and what does happen is that after a couple of weeks, a couple of months, an employee decides that he actually changed his mind and returns to work. Obviously, if the employer hasn't gone through the motions of dismissing the employee prior to this, the employer will still have an opportunity to convene the disciplinary hearing. Now, although I've characterized this absence without leave in these three broad categories, there is often an overlap. So it's quite important for employers to be cognizant of the overlap and to carefully select what they're going to charge the employee with in order to justify a dismissal. And I'd just like to end off by stressing that for dismissals in this regard, the employer must ensure that there's a substantively fair reason to dismiss the employee and that a fair procedure is followed.